you must master the facts of your case. On facts, you should not falter. I was not a very bright student, so I landed up in law. If you think that judgeship is a rosy thing, is a cool thing, it is not.
Greetings and welcome to Judicata, the NLIU Law Podcast. My name is Tarun Chettupalli and I shall be your host for today. Our guest today is someone who started at the bar in Chandigarh. He was later elevated to the bench of the Punjab and Haryana High Court. He later sat at the Patna High Court and also served as the Chief Justice of the Madhya Pradesh High Court. He was later elevated as a justice at the Supreme Court in the year 2018, where he authored almost 200 judgments. Some of the most notable ones, which include the Maratha Reservations case. He also wrote the lone dissent in the tribunal's reforms case and authored one of the two opinions in the Karnataka Hijab case. He then spent nearly 3 years as the chairperson of the Indian International Arbitration Centre. It is our privilege today to welcome former Supreme Court Justice Hemant Gupta. How are you, sir?
Thank you.
Sir, today we want to know a bit about your journey as well as the broad themes that you worked under, which is constitutional law, arbitration law. So, sir, beginning with your journey, your father was someone who retired as the Chief Justice of the Punjab and Haryana High Court. Did that in any way have influence over your choice of career being law, and was it always your natural choice?
Actually, my first choice was not profession. I wanted to be engineer.
Oh.
But as the law would have been, I was not a very bright student. So I landed up in law. More as a matter of compulsion rather than as a matter of choice. But once I entered profession, then I made a conscious effort to work hard, and the God willing has helped me. You know, in profession, hard work is the only way out. You know, sometimes the youngsters get inspiration from the few successful lawyers. They are exceptions.
Right.
But at the pyramid is always the broad, and one has to make an effort to rise up the pyramid.
Right.
That may be your target, to reach at the top, but you can't reach top in one go.
Right. And so, on the topic of youngsters, for the young people who want to join the judiciary at a later stage, what would be one myth as a judge that you'd want to bust for them on like something you realized through your way in your professional career?
No, if you think that judgeship is a rosy thing, is a cool thing, it is not. Judgeship is actually very difficult. A judge is said to live like a saint. But things have changed, you know. There was no interaction. You know, we were advised by our seniors not to have social interaction, less meeting with people. But things have changed in 40 years since the day I joined the profession. It is not luxurious.
Right.
You know, when you enter courtroom, you feel that everybody gets up for the judge. So it's a cool thing.
Right.
But that's not. You get habitual of it in one day, you know, because you do it as a matter of routine.
Right.
Nothing particular. The lawyers do it as a matter of routine. The judges do it as a matter of routine.
Right.
But that is only one view. But behind all that you see in court, there are a lot of work which goes in chamber.
Right.
You have to read all files, otherwise anybody can take you for a ride. Then after you finish the court work, you have to dictate with the orders.
Right.
And dictation of the order is not easy, because it's easy to argue the matter, but to articulate in a black and white, in a proper format.
And so, as you said, the landscape of law has really changed in the last 40 years since you joined the profession. Now, Another aspect of law that has come up is the life at law firms and now students choosing a corporate setup. For students now contemplating whether to go into litigation or whether to go into a corporate law firm, would there be any advice that you'd want to give on what are the balancing factors they should take into consideration?
You see, the financial condition of a student is very important. I was told that some students have to raise loans to study. In our time, there was no private law colleges, law universities. So it was easy. Government school, law colleges, the fee was minimal. And even if you go to the hostel was also economical. But now things have changed. So if the financial constraints are not there, I will prefer the youngsters to join profession, because as a lawyer, there is a long gestation period.
Correct.
One should be sure of it that 5 to 10 years it will take, because that is a long period.
Correct.
Then you need financial support to survive. For a person who has taken loans or financial condition is not such, there is no option but to make money, start earning. Because the parents would say, कि पढ़ा दिया अब तो काम करो ना.
Right.
So it's a difficult choice.
Right.
But some people who do well in the profession, again, I told you informally now, that don't try to look at the top of the ladder.
Right.
In High Court, there was 2-3 lawyers, well-known lawyers, including father of Mr. Kapil Sibal, very well-known lawyer. So if you want to say that you want to be at that stage, he has done 50 years of hard work. Only then that he has reached it. You have to do hard work, only then you can reach up to that level. So it takes time, but profession, I would say, is more rewarding.
Now, sir, I want to talk a little bit about your digitization work in the high courts that you've been at. What was the purpose behind it, and what was your ideology behind putting in and investing in the digitization of courts? And now that there's so much technology even being used within courts, the emergence of AI with advocates, with judges as well, how do you see that, and what was the purpose behind it?
When I was assigned this computer committee, I was earlier member. We thought that there is a voluminous record which is lying in the archives. So we should digitize it so that it should be, actually it was basically to utilize space. But then we realized that unless we make it attractive to the users of the technology, like advocates or the litigants, then it will be not enough motivation. Right. Then we started availability of digitized record to the advocates. They can have any copy of any document. Otherwise, earlier physical inspection was required to be done. You could only carry the lead pencil to note it down. It was physically constraints were there. And we also made thought that way, that all record should be available to the members of the bar or to the litigant at a cost. So it became easy for the lawyers that they can get copy of the entire record. The corresponding effect was the litigants were not getting copies of the orders passed.
Right.
That was one difficulty in my court. The copies will take about 6 months to get a copy. 6 months is a conservative estimate. And for an urgent, for interim relief, there were 3 categories: ordinary, urgent, immediate, that kind of a thing, and you gradually pay. But even those copies were not available the same day. So with digitization of record, digital signatures, a stage came when the copy of the order we could get the same day. That was a major change for the litigants, that it becomes faster.
Right. Do you think that the advent of AI has changed how litigants are coming into proceedings and also how judges are now viewing arguments or making decisions?
No, personally speaking, I asked my law clerk to summarize the pleadings of one case. He used it, but the end result was not satisfactory. Summarizing is what is already there. You have to concise it. If preparation is not successful from the AA angle, then what is the use of it?
Right.
And of course, you can't use it for judgment writing. Maybe you can use it for clubbing of similar cases.
Right.
Like very common, there's a huge tendency of motor accident claim compensation before the High Court.
Right.
You can have the categorization with the aid of IA.
Right.
Like death cases, insurance claims, what is the issue, what is the income, what is the age, that kind, it can be done.
Right.
But ultimate decision, even with that brief intervention, has to be of the court.
Right.
Judgment writing can't be outsourced. Right. The human mind has to there. You can't depend upon machine decision.
So another aspect of digitization that the courts have seen, and we even discussed this before, that is the live streaming of cases to the ordinary public. Now, one of the side effects of this is also that statements made by the bench will be clipped and also put on social media. And as we've seen, there has been outrage about that before. What is something that, do you firstly think it's an advantage to the public? And secondly, do you think the outrage is valid?
No, the idea of live streaming was that the students of law, the members of the bar, will benefit from the depth of the arguments. I don't know, any of you remember what was the level of arguments in Sabrimala? Nobody will remember that. Nobody would have watched it. But one clip which has gone, actually couple of clips which go every day, is something which is negative. Negativity is more popular than the positivity. There's a pitfalls, but we should learn to live with it.
Right, absolutely, sir. And so one of the final questions with respect to the practice area itself is that the Supreme Court had recently also restored the 3-year practice requirement. Do you think that such a requirement is something that's very necessary for practical experience, or does it come with the practice itself?
Theoretically, it looks nice, that 3-year experience. But I remember there was one judicial officer appointed as additional district judge. Additional district judge, you have to have 7-year experience. Got a certificate from a lawyer that she was practicing in his chamber. Never came to chamber, never came to court, no idea. So even that kind of misadventures would start.
Right.
I would say for a youngsters who is freshly graduating,
right,
for him, law is not a first preference. He's looking for an opening in the government sector, right, with a profile job where all India services, police services, right, it's so many avenues. Now, if 3 years hiatus is given, what will happen? All the bright students will get into other services.
Right.
And judiciary will remain with not so bright.
Right.
So my idea would be that the candidate should be appointed at the first opportunity and train them. Whatever you may train them, but that is not the actual experience in the court. Actual experience is one learns by experience. But fact is that how many of them will actually learn in 3 years period? One was the common complaint whenever I used to go to the districts कि छोटे छोटे बच्चे हैं पर हम उसके फादर की एज के हैं बट हमें भी तू करके बुलाते हैं. Small thing, but it's a normal human behavior. How do you address a person who is senior in age, definitely more experienced in the profession? But if you go with the idea that since you are sitting at the dais, so you can say whatever you feel like, law is something which you keep learning every day. It's not in textbooks only. The practical application of law you learn only from the members of the bar. Right. If you are open to the idea of learning, you will learn. Right. If you think that since you are a judge, you can do whatever you feel like, you may still do it. But that will not be a personal growth of you as a judge.
Right. So it's true that law really does not just come from textbooks, it also comes from practical knowledge. Now, were there any mentors in your life that you'd want to talk about who really shaped the way that you look at the law and from whom you understood how the law should be working?
No, and when I started profession, my senior was working in district courts. Then when couple of years later, I shifted to High Court, so I was again with the senior. But they were these two mentors. Even though you are successful, there are certain issues where you are at the crossroad. Right. Which way to go? So we'll ask my senior in district courts, who was both of them were actually very good in civil law. But the lawyer in district court, I would consult him. He will only say, ये भी देख लीजिएगा. Giving me a direction to look into. Right. Not that he will tell me to look into the provision or, this direction.
So now I want to pivot the conversation towards constitutional law, as you worked a lot in it as well. I want to ask that across these 4 decades that you worked, have you noticed that has the judiciary now moved from judicial restraint to judicial activism? Why I ask this is in the tribunal reforms case, you were the lone dissenter, and you also said the legislature isn't bound to legislate the way the courts direct it to. Now, sir, what is your opinion in this? Have the courts now moved towards judicial activism, or do they still practice the necessary restraint that's required?
No, actually, judicial activism is not only in this context. Judicial activism is started in 1990s when judiciary wanted to suggest that how the things should be. One explanation of the judicial activism was, since the executive is not doing, so somebody has to do it. But that is not the way, according to me, judiciary is expected. Judicial activism may be necessary, not in the sense because the executive is not working. Maybe there are certain loopholes in law. Even that loopholes you can't fill up by judicial interpretation. But basically, I will be not in favor of judicial activism.
Right. Now, sir, every judge has a certain set of experiences that they come with certain kind of backgrounds that they come with. Now, do you think that these experiences shape the kind of judgments that they give, or does every judge end up as a neutral party listening to arguments? Does this affect their interpretation of the Constitution, or are the rules fixed for everybody?
No, I will presume everybody is neutral. We'll go by that. But there is a background in which, as a child, we grow. Right. As an adult, we shape up. Now, if our upbringing, our atmosphere in the family or in the school or in the society in which you live is, say, conservative, I would say, like my family was conservative. So your ultimate shape would be conservative.
Right.
You can't overnight say that you have become liberal. So somebody whose family attitude or family upbringing was liberal, the attitude will be liberal.
Right.
So both are, though neutral, they have brought up in two different environments. The result would be the same.
Now, in the hijab case that you had worked on, you and Justice Dhulia had read the same record, the same constitution, the same facts, but had reached opposite conclusions in that case. Now, do you think this is a limitation that exists, or do you think this is the exact strength that our judiciary works on the basis of these opposite contradictions that we might have?
I think it's a strength.
Right.
No, everybody is free to express one view.
Right.
And that the best comes out of it.
Right.
I had my view, wrongly or rightly. So is Justice Dhulia.
Right.
But unfortunately, the matter never was listed thereafter.
Yeah.
The essential religious practice was one of the issue in those matters.
Yeah. One more question that I'd want to ask you is, you've been part of these cases, and behind all of these cases, always a looming public opinion, a public sentiment, and these also involve religious sentiments within it. Now, in cases like Sabrimala and the Karnataka Hijab case, how does a judge keep themselves away from such public sentiment and make an objective view of the case?
No, this public sentiments or the public opinion or the mass opinion, you can say, should not influence a judge. We have to go, because this Karnataka Hijab case was also very hotly contested. In the same environment, both of us has given a different opinion.
Right.
So not really getting influenced by the public opinion.
Right.
No, what I told you earlier, your upbringing or your mental attitude,
Right.
which you grow with which is developed with the passage of time, that is what is ultimate result of the judgment.
Absolutely, sir, absolutely. Now, sir, I would also now want to cover your experience in arbitration and other institutional reforms that you've been part of. You've been a chairman with the Indian International Arbitration Centre. How was that experience like? And you have also seen an institutional side of things apart from being part of the bench. So how does arbitration look from the other side?
The arbitration landscape is very challenging. There are many factors to develop an arbitration in the country. Firstly, the litigant's mindset. And litigant is all again advised by the advocates, by the law firm or advocates. And then ultimately, the opinion they form by seeing the arbitrator's work. After the award is given, again the issue is how long the court takes to decide it.
Right.
The finality is one important thing. Everybody is interested to get a finality in the matter.
Right.
But not that it should remain pending. 2 years back, I was in my hometown, Chandigarh. One of my friends came to meet me. He says an award given by a former Supreme Court Chief Justice is subject matter of challenge in the High Court for last 10 years.
Right.
So that is the factor.
Right. And so, but on the topic of this, do you think the courts still hold a very interventionist nature in our arbitration landscape? Or do you think such court intervention in the first place is necessary? Because Section 9, 11, 34, and 37, these are constantly used in the courts, and this is what drags the matter on for a very long time.
No, court intervention has to be minimal.
Right.
I always recommended this. In T.K. Vishwanathan Committee was constituted on my suggestion that we need review of the arbitration law. But what the ultimate report came was not what was my idea. My idea was that how to reduce court intervention. But the entire report, there is no chapter on that. Court intervention has to be minimal. My suggestion was that there is a provision for emergency arbitrator that takes care of Section 9. Section 11 should not be there. The Arbitration Council of India should be effective in even the existing regime, where you have graded arbitrators for appointment. There is a pool of arbitrators which become available for the court. As of now, there is nothing.
Now, sir, with respect to pool of arbitrators as well, now, do you think arbitrators should also come from beyond retired judges, like, let's say, CAs, engineers, and all of these other professionals in respect to specialized matters? How do you think that plays out in the real life?
Yes, it should be.
Right.
Because judges is only one part. CAs, engineers, the bureaucrats can also be the pool, the lawyers. At one point of time, we wanted to have MSME arbitration in the center. Our rule was age group 35 to 70. But in that, I suggested that it should be 25. The youngsters should be given an option to be an arbitrator. We have to train them.
Right, absolutely.
Without training, nobody will know what the arbitration is. But things don't move the way sometimes you plan.
We have also seen the 2024 draft bill for arbitration, which had come out, and it lets parties now appeal to a second arbitral panel instead of going to the court, but it leaves ad hoc arbitration outside. And this is how most of the Indian arbitrations happen, as we had discussed. Now, is this gap worth fixing, or is this a good step towards progressing?
No, the idea is that India should move from the era of ad hoc arbitration to an institutional arbitration.
Right.
If there is a dispute resolution mechanism within the institution, probably people may prefer institutional arbitration. Ad hoc arbitrations are better.
Right.
So let them slog 34 and other things.
And so you've also said that public policy is a clause that causes some trouble. Now, the draft bill would extend patent illegality to international arbitrations which are seated in India. Now, do you think this is a step forward, or are we regressing back in arbitration in India?
You look at the clause public policy. How do you define a public policy?
Right.
That is subject matter of interpretation from day one. When this 1996 Act came, I was practicing law and doing arbitration matters also. The moment I read it, I said that is a mine of disputes. And what ultimately the court said, that public policy is patent illegality. How do you define patent illegality? These words are not, can't be defined. You have to leave it to the wisdom of the court. Public policy was absolutely vague. Patent illegality, there are some judgments, but public policy, there was hardly anything. No, according to me, to meet WTO deadlines, we copied ancestral model of law, picked up verbatim with no change in comma and full stop, made it a law. In no other law you will find appointment of an arbitrator by the Chief Justice of the court. Here we give preference to the institution. And that amendment, that mistake was undone in 2015, 20 years later. It may be good ancestral model for the European model. How do an Indian work? How do the Indian system work? We should make a law according to the Indian needs.
Now, sir, on the topic of this, just one thing that we had noticed, that large public contracts and such public nature of infrastructure developments are being kept outside the scope of arbitration in India, where it was said to be non-arbitrable in nature, maybe. Now, do you think this is also acting as a hindrance because there were some highway projects which were kept outside the scope of arbitration?
No, the basis of all this is an office memorandum issued by Government of India, if I remember correctly, 3rd of June 2024. That is actually in the context of ad hoc arbitration. What the government should have done is that instead of ad hoc arbitration, it should have said that go by the institutional arbitration. Right. Actually, I tried to lobby for change, but I was not successful.
Right. Now, so one of the more final questions with respect to arbitration. Now, Singapore, Hong Kong, London, these have been the prime seats for arbitration, while India is now striving to be an arbitration hub. What do you think the changes have to be to bring this change that's necessary? And also, if you had the opportunity to actually draft the bill of 2024 and make any changes to it, what would they be to make India the hub for arbitration now?
You know, Singapore, London, or Hong Kong and Singapore are city-states,
right?
Small states, one center.
Right.
So they have made an effort to publicize themselves, to make it popular. Singapore still holds 2 conferences in a year in India. And same way, not the London, but not the Hong Kong, but Singapore is the one. It's a publicized, and then they have providing an efficient system where challenge to an arbitration award becomes final in less than 6 months. Here, in 6 months is only the notice will be served today.
Right, sir. And now moving to a more closing note, sir, I want to ask you a few lighter questions. In your years of judgeship, have you ever seen a lawyer that you would like to mention whose advocacy made you think that, oh, that's the way someone should argue, or something that really struck a chord with you?
Yes, obviously there are times you feel like that certain lawyer is worth emulating. I particularly remember a particular lawyer who was arguing a rent matter before me. So I had a particular view, but I was not able to accept his argument. Then I told him in court that I'm confused, I will take up some other day. So that is the level of advocacy. In another matter, I had taken a view the rebuttal evidence should be allowed on all issues or only on the issues which are on the defendant. I had taken a view, but then a particular lawyer, he argued that no, I know that you have taken a view, but let me explain your view is not correct. And after hearing, I found that probably my view requires reconsideration. I referred it to larger bench.
Right.
It's my view, but the lawyer had persuaded me to take a different view.
Now, sir, another thing is, can you tell me like one thing you miss or you don't miss about being a judge or your days as a judge in the last few years?
No, as a profession, as a lawyer, you had enough time between the cases. You know, in the High Court, we used to utilize that time for having a coffee with a couple of friends. We'll wait outside the court and we'll ask our staff to get coffee there. And some light-hearted moments. No, those moments are not possible. I miss that.
Right. Absolutely, sir. And one of the final things that I want to ask you now is, if you had to give one advice to young lawyers or people who want to join the judiciary now, what would that be? And if you could go back in time, what would be one thing that you'd tell young Hemant sir on what he should do?
No, basically it's a profession of patience. You should have patience and also hard work. I remember my grandfather was there when I joined profession in 1980. Before going to court, I went for his blessings. He gave me 2 things. Says, you must muster the facts of your case. Right. On facts, you should not falter. Because if you are master of your facts, you can possibly check the other lawyer.
Right.
If he's not stating the facts correctly.
Right.
So you can correct him, and correct yourself also.
Right.
Says even if you don't know the law, that will still work. But facts you can't.
Right.
And the other was that you have to do the hard work.
Absolutely, sir. And is there any courtroom film or book that you'd like to suggest to the listeners that they should watch this or they should read this before going into the profession?
No, when I was a student, actually pre-engineering at that time. At that time, this Keshanath Bharti was being argued.
Right.
And Nani Palkhivala used to be the arguing. And newspaper on the front page will carry the argument that this is what Palkhivala argued on a particular day. So Palkhivala became my role model. And later on, I tried to find out that how come a particular lawyer argue for 40 days? Then I was told that he was a bright lawyer who could foresee that on the next Monday, he will argue on this proposition and advise his team to prepare accordingly. So his schedule was like this, where he would conceive a particular argument to be raised on a particular day and assign that project, that theme to a lawyer.
Right.
So that kind of understanding of the lawyer is must. And you must remember, or you must have read it, Keshanath Bharti was sought to be disputed. There is no order on the file being disputed and no order how it was closed. But Palkhivala again stood up and persuaded the bench not to venture into this.
Right.
So Palkhivala's book on Palkhivalas is very important. It's written by Soli Sorabji and Arvind Datar.
Mm-hmm.
The second book I would recommend is Roses in December by N.C. Chagla. The last one is Fali Nariman's autobiography. No, if you want to be a successful lawyer, you read what the others have done.
Absolutely, sir. Thank you so much, sir. It was actually a privilege talking to you, and it was a very good conversation. I'm sure the listeners learned a lot. That's kind of it, sir. Thank you so much.
Thank you so nice of you.